The Supreme Court is hearing arguments today for a pair of cases that could fundamentally change federal government regulations. The justices are weighing challenges to a 2020 regulation requiring fishermen to pay for monitors who collect data while they're at sea. Underpinning this dispute is what's known as Chevron deference. It calls for courts to defer to an agency's reasonable interpretations of ambiguous laws passed by Congress. The name is taken from a 1984 landmark decision. If it's overruled, it could impact countless areas such as healthcare, the environment, consumer safety, and government benefit programs. Jessica Levinson joins us now. She is a CBS News legal contributor and a professor for Loyola Law School in California. Jessica, this is a big deal, but it's not very well understood by most folks. Explain to us exactly how Chevron deference works to try and empower executive agencies, where it goes right and where it goes wrong.
This is a big case. I'm teaching my first constitutional law class of the semester tonight, and we're going to start by talking about this. I think it's bigger than the cases facing the Supreme Court this term that refer to President Trump and his legal questions. So this is about when there is a congressional statute and it is open to interpretation. Do we defer to a federal agency's interpretation as long as it is reasonable? I know that sounds like it's in the weeds, it's wonky, but we just saw that great graphic of all of the different areas where federal agencies interpret congressional statutes and make regulations interpreting those statutes in ways that deeply affect our lives. We can see it on the screen there: healthcare, the environment, consumer safety, government benefit programs. So legally speaking, the question is, when there's a statute and there's some question about congressional intent, who do we defer to? Do we say federal agencies who are staffed with people who are frankly experts in the area, they get the last word as long as that interpretation is reasonable? Or do we essentially not give them any deference, and do we give that power instead to federal judges to interpret congressional statutes and to try and divine what Congress meant?
In some ways, it almost seems like on par with Citizens United, that it has a potential to really remake the way that our democracy, our government functions. But let's be really specific, Jessica. Give us an example of a type of thing that could change if the 1984 ruling is actually overturned by the Supreme Court.
Well, the Biden administration is certainly worried that this case could be overturned because much of the climate change agenda is based on the idea that the EPA can create pretty rigorous rules when it comes to pollution, when it comes to electric cars, et cetera. But one of the famous examples from just a few years ago comes from a circuit case where the question was, how many pollutants can be dumped into the Chesapeake Bay? And under the congressional statute, the EPA determined that it is essentially X. And the circuit court said, you know what, we're going to defer to the federal agency on that. We're not going to substitute as judges our own view. We're not going to engage in policy making. And so when it comes to these questions of environmental protection, and just that one example of how many pollutants can you put into the Chesapeake Bay, we see that there are so many steps, there are so many cases over the 40 years where it's been the Clean Water Act, or it's been competition among regulators of internet service, or it's been anything dealing with workplace safety, where a court has said the agency made that interpretation, we'll defer to it.
Jessica, real quick, given the Supreme Court's conservative bent, do you expect that they will side with the fishermen?
I do. Oral arguments are ongoing. We're entering hour 3 right now. But if you listen to their questions, I think I counted, although we can never be sure, 5 votes to overturn the doctrine.
All right, Jessica Levinson, thank you.